Former President Donald Trump's historic hush money trial resumes today. We'll speak with a legal analyst about the ongoing trial and Trump's other legal issues. Good morning, San Diego's 8 a.m. hour starts right now.
This is Good Morning San Diego.
Former President Donald Trump's hush money trial continues today. When we come back, we'll speak with, we're going to speak with him right now, criminal defense attorney Vikas Bajaj. Vic, we keep calling it a hush money trial. It's really a bookkeeping trial, is it not?
It's a non-disclosure accounting trial.
All right,
so yes.
So with that said, then what, I get that the prosecution wants to bring out salacious details, but the satin pajamas, the spanking, do we really, what does that have to do with the bookkeeping end of the charges here?
I can't believe you don't see the relevance of that. Whether you're wearing silk pajamas or satin pajamas is clearly an IRS and an accounting issue. All facetiousness aside, this is evidence that could have been avoided completely because it is irrelevant in this case of a bookkeeping and accounting question and a fraud question by stipulation. The problem is the prosecution has made it very clear they want to drag the defendant in this case through the mud, so the jury, who has to make an ultimate decision on factual innocence or guilt, says, I just don't like the defendant. I don't like former President Trump because of what he did, and he cheated on his wife a year after they were married. I'm not giving him any benefit of the doubt. The stipulation was there for all parties to enter into, but consciously and specifically and affirmatively, the defense attorney said, we want the stipulation, Judge. The jury shouldn't hear this. And the judge says, no, the jury will hear it.
And the way I understand the rationale behind that is it's important to hear how salacious the details were because it would have affected the outcome of the 2016 election had people been aware of them. You say... Can you speak to that?
Yes, there's what we call prejudicial evidence in the court of law. That's fine. Evidence can prejudice a defendant or prejudice a plaintiff or a prosecutor. Where the law comes into play is to avoid unduly prejudicial evidence. So one would ask, these details, are they relevant to proving the impetus for buying the silence, as the prosecution says? The answer, I believe, an appellate court will find is no. The very act of the extramarital affair is all that needs to be portrayed to the jury. The pajamas, the missionary style, and all this other stuff that's just unnecessary and inconsistent should never have been allowed by this court, in that court or any court in our union.
Vic, I listened to all the Legal Beagle podcasts just to get the latest on this, and one theory I heard is that they will go through this, assuming they don't get a hung jury, that they get the verdict against the former president, then they will delay the sentencing until well after the election, perhaps permanently delay the sentencing, that way to avoid the appellate court. What are your thoughts about that?
That would take an agreement by the defense. Sometimes there are strategic advantages to continuing or prolonging a sentencing. That would be to develop mitigating evidence, to have victim statements and mitigating statements to support the defendant. However, in this case, the defendant also has a right to a prompt sentencing. I don't put much faith in that argument, although, of course, Paul, reasonable minds can differ.
Yes, and right now we should mention that Stormy Daniels is on the witness stand getting what I would assume is a vigorous cross-examination. She hasn't held up well in her first part of her cross-examination. They caught her in various discrepancies between what she's saying and what she wrote in her book. But we'll leave that for our next conversation. Right now, can you just take us around the horn? Things in Florida have been, the Florida case is now permanently on ice. The Atlanta case appears to be, Fonnie Willis there is in hot water and maybe will get yanked from the trial. The D.C. court case is held up by the Supreme Court. Is Trump winning on several of these arenas?
Yes, and just with a sort of a 30,000-foot brush, let's talk about Florida. Judge Cannon in federal court said we have serious issues. If you read the judge's issue, she recites something called CIPA, C-I-P-A. That is the Confidential Information Protection Act. This requires a judge to look at all the evidence that may be provided to the jury and also the defense. This is evidence that's in the prosecution's hands only. Judge Cannon has to review all of that, then make findings that certain pieces of evidence can be disclosed. Having litigated SIPA motions, they are extraordinarily complex and time-consuming. So that case is on ice for a while because those issues cannot and should not be resolved. Exactly. Now we talk about the Florida state case. The appellate issue specifically is whether this district attorney should have been disqualified in appellate issues. Some may call it an interlocutory appeal. That's going to take time because if trial courts move slowly, Paul, as we've talked about, appellate courts are really just a lot slower behind.
And then that brings us to D.C., which can't proceed until the Supreme Court rules, right?
Exactly. And specifically, the issue there is presidential immunity, which would have significant aftershocks and waves affecting all the cases against President Trump.
Which brings us all eyes back to New York City, which we will continue in our next conversation together. Okay, Vic?
Thank you, Paul.